Hello again. The subject of this video is entities. We're going to be building on what you learned about entities in your corporations or your business organizations class. And at the risk of beating a dead horse, I want to talk once again about who is your client. Is it this person, the majority stockholder and chairman of the board? Or is it this person, the chief executive officer? Or perhaps it's this person, the assistant treasurer. And by the way, this last person is the person you're more likely to be dealing with as a first-year associate. But are these your client? And the answer is no. But technically, legally, and ethically, these people are not your clients. Here is your client. Your client, as Heidi said in the last video, is a business, but more specifically, your client is an entity, or in the case of this business here, a group of entities. And here's, in this diagram, where we see Clothes Kingdom, with its various subsidiaries, including Boxy Suits, Inc., which it's in the process of selling to Baron Wuffett. The three kinds of legal entities that you're going to be working with most frequently are corporations, limited liability companies, and limited partnerships. All of these entities are creatures of statute. They're all created in the first instance by the filing of a specific document with the Secretary of State of one of the states. Now, the default body of law, or bodies of law, that we're going to be using when we talk about entities is Delaware law. The Delaware law applicable to corporations, limited liability companies, and limited partnerships. And that is because Delaware is really the default state, or the state where a large percentage of business entities are organized. But for the kinds of things we're talking about in this program, the differences between states' laws are probably not going to be that significant. So these kinds of entities have numerous similarities. In each case, the entity is governed by its organizational documents. And when we say that an entity is governed by these documents, it means that the decision-making process relating to the entity and the rights of equity holders are set forth in the entity's organizational documents. And the term organizational documents means, in most cases, two documents, as shown on this slide. And in each case, you'll see that one of the documents, the first one, which is marked with an asterisk, is the document that originally gets filed with the Secretary of State to create the entity in the first place. And the second one is not filed with the Secretary of State. Another similarity that all three types of entities share is that they all issue equity interests. And the equity interests they issue represent ownership of the entity. Entities have to be owned by somebody. And the names for the equity interests are different based on the different kind of entity. For a corporation, we talk about common and preferred shares. For a limited partnership, the equity interests that are issued are limited partner interests and general partner interests. And for limited liability companies, there's many names that get used, but the most typical ones are membership interests or LLC interests. And when equity interests are issued to investors, those equity interests usually embody some combination of rights, both economic rights and, in many cases, control rights. And we will be talking in subsequent segments about those kinds of rights in more detail. I've talked about the similarities of these various entities. What are the differences? Well, the primary difference is that corporations, which are governed by corporation law, are subject to laws that were essentially written 100 years ago, whereas limited liability companies and limited partnerships, the statutes that govern those kinds of entities were written in the last 40 years and provide for a much greater amount of flexibility, both in terms of how the various economic and control rights that equity holders can be divided up, and also, in many cases, how the governance mechanics work. Whereas corporations, you're tied up to a much greater extent by what the statute requires. Because most of the deals that you're going to be working on involve entities as the parties. In fact, it's a pretty rare transaction where either your client or one of the other principals in the transaction is going to be a live human being. Because of this, there are a set of legal issues pertaining to entities that come up in every transaction. And we're going to be talking more about these when we meet in Chicago, but I just wanted to give you a preview of these issues because they come up in many different contexts, and in fact, many of the contexts they come up with are going to be directly related to work that you're going to be doing right out of the box as a first-year associate. So these issues are going to be a very significant part of your early practice. The issues all flow from the fact that we're dealing with entities. And here is an entity, and it's a box in a chart, as I've shown it here. But in the real world, the entity, even though it's a real person under the law, it has no real existence. You can't touch it. It doesn't have any corporeal existence. So when the deals that you're working on, which involve entities, when it's time for contracts to be signed, which purport to bind those entities, and that's a big part of what you're going to be working on, those kinds of contracts, the entity itself can't sign the contract. Instead, a human being is going to sign the contract on behalf of the entity. And the issues that I'm talking about here, and I'll be talking more about later, all relate to the same question, which is when the human being signs that contract on behalf of the entity, is the entity legally bound? And obviously, in our deals, we want the answer to that question to be yes. So a fair amount of effort is exerted in looking at the issues I'm about to describe to you to make sure that the answer to that is yes. So what are the issues that all tie into this question as to whether there's a proper nexus of authority between the entity on the one hand and the human being signing the contract on the other? And there are 4 issues. And again, we'll talk more about them as we proceed. The 4 issues are, number 1, does the entity exist? Seems like an obvious question, but as you'll see, not necessarily so obvious. Number 2, does the entity have the legal power to sign the contract and to perform its obligations under the contract? Number 3, have all the steps required by the relevant statute and the entity's organizational documents been taken to authorize the entities entering into the contract? The way I like to describe this is, has the entity really decided to do this, to sign this contract, to enter into this transaction? And the last of the 4 issues is, and it goes to this little person with a pen is, has the contract been duly duly executed and delivered by an appropriate person with the appropriate authority? So those are the four big issues, and these issues come up in the negotiation of contract provisions, specifically reps and warranties, which we'll be talking more about. They come up in the context of legal opinions. They come up in the context of closings and standard closing documents that we see in every deal. And this is where you come in order to get the level of comfort we need to get in these other contexts, these issues are the subject of due diligence that's typically going to get done by the junior lawyers, that is, by you. So now I want to talk about the fact that most businesses, most of your clients, and most of the businesses who participate in the transactions you're going to be working on consist not only of one entity, but of multiple entities. Here again is the slide of Closed Kingdom, and we can see that Closed Kingdom has subsidiaries, 5 subsidiaries, and the term subsidiary is it's defined differently in different places, but essentially in most circumstances when we refer to a subsidiary, we're talking about a subsidiary with reference to, say, Party A. It's another entity as to which Party A owns a majority of the voting power. So it's another entity that's controlled by Party A. Now, in our slide here, it's really very simple because all of these subsidiaries of Closed Kingdom are either directly or indirectly wholly owned by Closed Kingdom. Closed Kingdom owns 100% of the outstanding common stock of the first-tier subsidiaries, and the first-tier subsidiaries own 100% of the stock of the so-called second-tier subsidiaries. Now, this is a privately owned company. You can see that all of the equity of Closed Kingdom, which is the top company or the parent company, is owned by 3 human beings. In fact, 3 family members. This is a privately owned company. If we were to try to show a chart like this showing the corporate structure, that is the structure of all the entities that make up the General Electric Corporation business, it would probably be impossible to show it on one slide. We don't really know how many subsidiaries GE has because that's not publicly available information, but my guess would be it's in the thousands. And why is that? Why are there multiple entities and businesses? Well, number one, GE, for example, does business in probably 100 different countries, and every country has its own corporate law requirements, so you're almost always going to have to set up a separate entity to do business in a different country. But even Closed Kingdom, which does all of its business here in the U.S., has several subsidiaries. And why is that? Well, one of the reasons we use different entities is to wall off liabilities in a way that I'll describe in a few minutes. Another reason is when companies are acquired, they're often acquired in the form of an entity, and so when you acquire a business by acquiring an entity, that then is a new subsidiary. There's organizational reasons why you might want to have your business divided up into different entities that in order to run different, say, product lines or different businesses. So there's lots of reasons why businesses are composed of multiple entities. It's important to know that your clients, business people, when they are looking at a business, they're considering, doing a transaction with another business. They're considering buying a business. They're considering investing in a business. They're considering making a loan to a business. They're considering entering into a joint venture with another business. When business people are doing that kind of analysis, they are looking at the business as a whole. They're not looking at the business the way we're seeing it on this chart. Instead, they're looking at the thing as a whole. And one of the key documents that they're going to be looking at to determine the financial condition and the historical financial performance of a business is that business's financial statements. And the financial statements that are typically looked at and relied on are so-called consolidated financial statements. And what that means is that the financial condition and performance of all of the entities that make up a single business are combined. So the business person is looking at the whole thing, and they're really not paying much attention, if any at all, to the fact that the business is composed of multiple entities. The lawyers, on the other hand, are often required to dig beyond what the business people are looking at and understand not only the corporate structure, that is the different entities that make up the business and who owns whom, but also where the assets and liabilities of the business are. And this is a very important point. If you take any particular asset of the Clothes Kingdom business, whether it's a piece of equipment or a trademark or a pencil, it's most likely that that asset, that piece of property, is owned only by one of the multiple entities. Now, there are some cases where property, where assets is owned jointly, particularly in the case of real estate where you have tenancy in common and joint tenancy, but most personal property is owned by only one person, and in this case, only one entity. So the business people are maybe looking at the assets of the business. The lawyers, in many cases, have to understand what the entity structure is and who owns what assets. Likewise, the lawyers have to know which entities are responsible for which liabilities. Because as we're going to talk about in more detail, a liability, particularly a contractual liability, which is the kind of liabilities that we're going to be focusing on, is created with respect to one entity, the entity that signs the contract. If multiple entities sign the contract, then all the entities who sign might be liable, but not all of the entities in a business are jointly and severally liable for the other entity's obligations. So we need, as lawyers, to figure out what the structure is, the corporate structure, and often figure out where the assets and where the liabilities are. What I want to do now, and then we'll end this video, I want to give you a preview of with a couple of examples of the importance and the potential huge impact of what I just described in terms of the assets and liabilities of a business being allocated to one or more of the entities, but not to all of them. And I want to start with a very simple example. Here we have a single entity that has $400 of assets, and it owes money to two creditors. And these arrows in this kind of chart represent recourse. These creditors have recourse or claims against this entity. One creditor has a $600 claim, and the other creditor has a $200 claim. And for purposes of this example, neither creditor has a security interest in any of the assets, and neither one has a contractual priority over the other one. So the claims are treated equally under debtor-creditor law, and the magic term we use for that situation is we say that the claims are pari passu. So this company is clearly insolvent because its liabilities are twice the amount of its assets. So let's see what happens to the creditors when we liquidate this business. That is, we sell off the business's assets and use the proceeds of the sale to satisfy the creditor's claims. Well, what happens, because these creditors are pari passu, is that they share ratably in the proceeds of the assets. And in order to figure out how ratable payments are made, you essentially divide the amount of the assets, which is 400, by 800, which is the total amount of the claims. That gives you 50%. Each creditor gets 50% of its claim paid. So the $600 creditor gets $300, and the $200 creditor gets $100. Now, and this is where the kinds of issues that I've been talking about, and which we're going to talk more about later, these issues are going to come into play in this next slide, because I'm making the situation more complicated. Now I'm taking basically the same facts with one major difference, which is, instead of the business being composed of one entity, here the business is composed of two entities, a parent and a subsidiary. Once again, the business has $400 of assets. Once again, it has the same creditors, a $600 claim and a $200 claim. Once again, those creditors are unsecured, there's no priority between them, so they're pari passu. But in this example, the payout to the creditors is significantly different. Instead of each creditor getting 50 cents on the dollar, in this example, the creditor who's owed $200 is getting paid 100 cents on the dollar, and the creditor who's owed $600 is only getting paid 33 cents on the dollar, or $200, compared to the last example where they each got paid half. What I'd like you to do is see if you can come up with why that result would occur. And there's one, you might call it one fact or two facts, depending on how you parse it, but there's part of the factual picture I left out here. So see if you can figure out what additional facts you'd need to understand in order to come up with this result. And when we meet again in Chicago, we'll go through this again, and we'll see if any of you were able to figure this out. But the key here is that when we're looking at when we're looking at businesses that are composed of multiple entities, how important it is, particularly if we're representing clients who are doing business with those entities or relying on the credit or payment ability of those entities, how important it is for us to get an understanding of how the entities are structured and where the assets and liabilities are. Okay, so that's the end of this video, and I'm going to see you one more time on video in video number 6, and then we'll be seeing each other live in Chicago. Thank you.